For this video, we are going to talk about the factors affecting criminal intent. We have mistake of fact, Aberratio Ictus, error in personae, Praeter Intentionem, and Proximate cause. First in the offing is mistake of fact. What is mistake of fact? In mistake of fact, the supposed offender believes as true the facts perceived by him that impelled him to do a particular act. Otherwise stated, had the facts been true to the belief of the offender, his act would have been justified because of the absence of intent or dolo. And since there is no intent, then there is no criminal liability. For example, in the famous case of US versus Achong, Achong, who works as a cook, was suddenly awakened by someone trying to force open the door of the room. He sat up in bed and called out twice, "Who is there?" He heard no answer and was convinced by the noise at the door that it was being pushed open by someone bent upon forcing his way into the room. Achong, fearing that the intruder was a robber, leaped to his feet and called out, "If you enter the room, I will kill you." At that moment, he was struck just above the knee by the edge of the chair which had been placed against the door. Seizing a kitchen knife which he kept under his pillow, Achong struck at the intruder, who, it turned out, was his roommate Pascual, a houseboy who, in the spirit of mischief, was just playing a trick on him. Now, there had been several robberies not long prior to the date of the incident, one of which took place in a house where Achong was also previously employed as a cook. That's why he kept a knife under his pillow for his personal protection. It will be observed in the said example that Achong was of the firm belief that the intruder who forced open the door of his room was a thief in view of the circumstances obtaining at that time, such as the victim was trying to force open the door of the room. Achong asked the victim who he was, but the victim gave no answer. Achong, fearing that the victim was a thief or a robber, even warned the victim that if he entered the room, he would get killed. Still, the victim gave no answer. Instead of responding to Achong's questions, the victim pushed open the door, and Achong was struck just above the knee by the edge of the chair which had been placed against the door. Achong therefore acted in good faith, without malice or criminal intent, in the belief that he was merely exercising his right of self-defense. Take note, however, that mistake of fact is relevant only when the felony would have been intentional or through dolo, but not when the felony is a result of culpa. It is only a defense in intentional but not in culpable felonies. Let's take a look at this example. X was driving his car along a public highway. Thinking that the object that was crossing the highway at that time was just a cat, X did not slow down. As a result, he hit and bumped an old lady instead. Here, X cannot invoke the defense of mistake of fact, as this absolutory cause is applicable only in felonies committed by means of dolo and not by culpa, such that X here will be liable for the crime of reckless imprudence resulting in physical injuries or reckless imprudence resulting in homicide, as the case may be. For the law provides that no person shall drive any motor vehicle upon a highway at such a speed as to endanger the life, limb, and property of any person, nor at a speed greater than will permit him to bring the vehicle to a stop within the assured clear distance ahead. Also take note that the person invoking mistake of fact must not be negligent in ascertaining the true state of facts. Otherwise, he will still be held liable for the felony that is produced. For example, X, a security guard manning the premises of a convenience store, saw the cashier and a customer in a heated argument. X did nothing to check what was the argument about, nor did he get near the protagonists to prevent any untoward incident from happening. X, who was positioned behind the customer, saw the customer raise his hand, thinking that the customer was already aiming a gun as if to shoot the cashier. X shot and killed the customer, who it turned out was merely pointing his finger at the cashier. Here, X will be liable for homicide because he was clearly negligent in ascertaining the true state of facts. So here, X cannot invoke the defense of mistake of fact because he was negligent in ascertaining the true state of facts. The second factor affecting criminal intent is Aberratio Ictus. Aberratio Ictus in English means mistake in the victim of the blow. Here, the offender intends the injury on one person, but the harm fell on another. There are three persons involved in this scenario: the offender, his intended victim, and the actual victim. For example, X fired at Y but missed. Instead, the bullet hit Z, resulting in the latter's instantaneous death. Question: what is the criminal liability of X? Answer: X here is liable for attempted homicide or attempted murder, as the case may be, depending on the presence of qualifying circumstances. Attempted homicide or murder as against Y, and homicide or murder, as the case may be, as against Z. In the said example, the single act of X in firing his gun produced two felonies. One is less grave and the other is a grave felony. This is what we call a compound crime under Article 48 of the Revised Penal Code. Even if there are two felonies that arose from a single act, it will be treated as a single offense. That's why it's called a compound crime. And in such a case, the penalty for the most serious crime shall be the one imposed, the same to be applied in its maximum period. In the same example, what if Z survives? The answer is X will be liable this time for the compound crime of attempted homicide or murder as against Y and physical injuries, whether less serious or serious, as against Z. The reason here is, as against Z, only physical injuries can be charged because there was no or there is no criminal intent on the part of X to kill Z. Kasi yung criminal intent to kill or intent to kill only pertained as against Y because Y was his intended victim. Now, what if Z suffered only slight physical injuries? Will this result into a compound crime? The answer is no, because in a compound crime, the single act must produce two or more grave or less grave felonies. Since light physical injuries is considered only as a light felony, then it will be treated as a separate crime. So, don't be confused. No? When I say compound crime, kahit 2, 3, 4, 5 crimes yung maproduce by a single act, it will be treated and regarded only as a single crime. Kaya nga isang penalty lang ang ini-impose. The penalty for the most serious crime to be imposed in the maximum period. But in this example, kung slight physical injuries lang yung na-sustain ni Z, 2 charges will be filed. The separate crime of attempted homicide or murder as against Y and the separate crime of slight physical injuries as against Z. The third factor affecting criminal intent is error in personae. What is error in personae? Error in personae in English means mistake in identity. Here, the offender committed a mistake in ascertaining the identity of the intended victim, such that there are only 2 persons involved in this scenario, the offender and the actual or unintended victim. The intended victim is absent. For example, X wanted to kill Y. X then went to Y's house and saw a man whom he thought was Y standing near the door. X shot and killed the man who unfortunately turned out to be a different person, Z, not Y. X in the example above is liable for the death of Z. The fact that the victim was different from the one the offender intended to kill is immaterial. Mistake in the identity of the victim carries the same gravity as when the offender zeroes in on his intended victim. This is so because the offender is considered to have acted with such a disregard for the life of his victim without checking carefully the latter's identity as to place himself on the same plane as the one who kills his intended victim. Walang pinag-iba. Meron pa ring criminal intent kahit na ibang person yung victim. So, it will not mitigate nor exempt the offender from criminal liability because criminal intent is present regardless of the fact that the one who was attacked was not the intended victim. Question: in error in personae, what is the effect on the criminal liability of the offender if the intended crime and the actual crime committed are of different gravity? For example, X killed Y, his father, whom he thought was Z, his neighbor. Let us assume, for the sake of this example, that no qualifying circumstance attended the killing, such that had X killed Z, the crime would have been only homicide. In the example above, the intended crime, X wanting to kill Z, is homicide. But the crime actually committed, X killing Y, is parricide. Now, under Article 49 of the Revised Penal Code, the lower imposable penalty between the intended felony and the actual felony shall be the one imposed. Now, the imposable penalty for homicide, meaning the intended felony, is reclusion temporal, 12 years and 1 day to 20 years, whereas the imposable penalty for parricide, the actual felony, is reclusion perpetua, having a range of 20 years and 1 day to 40 years. In such a case, the penalty for homicide shall be the one imposed, but the same shall be imposed in the maximum period. This, in effect, is an extenuating circumstance. On the other hand, what is the rule if the intended felony and the actual felony are of the same gravity? If the intended crime is homicide, but the actual crime committed on a wrong victim is also homicide, or any crime having the same penalty, having the same gravity for that matter, then there is no mitigation of the criminal liability. The penalty to be imposed is the same. The fourth factor affecting criminal intent is Praeter Intentionem. Praeter Intentionem in English means lack of intent to commit so grave a wrong than what was intended. Here, the offender inflicts the injury on his intended victim, but the injury that resulted is far greater than what was intended. For example, X punched Y on the face. As a result, Y stumbled and fell on the road, with the back portion of his head hitting the cemented portion of the road surface. Y became unconscious and died a few minutes after. Question: is X liable for the death of Y? The answer is yes, he is liable for homicide. The reason is, criminal liability shall be incurred by a person committing a felony, although the wrongful act done be different from that which he intended. That is Article 4, Paragraph 1 of the Revised Penal Code. However, X can invoke the mitigating circumstance of Praeter Intentionem, because Praeter Intentionem is actually one of the mitigating circumstances found in Article 13 of the Revised Penal Code. But Praeter Intentionem, take note, cannot be appreciated if the means used to commit the desired crime would also logically and naturally bring about the actual felony committed. For example, X, angry at Y for elbowing him in a basketball game, got hold of a knife and stabbed Y on the chest. As a result, Y died. Here, X cannot invoke Praeter Intentionem because to stab someone on the chest with a knife will naturally and logically cause a person's death. Hindi mo pwedeng sabihin dito na wala akong intensyon na patayin siya, wala akong intensyon na mamatay siya, dahil yung ginamit mong weapon is a weapon that can actually kill a person. The last but definitely not the least factor affecting criminal intent is proximate cause. Proximate cause is exemplified by the following statement: the cause of the cause is the cause of the evil caused. Proximate cause is illustrated in the following example. X, holding a gun, declared a holdup inside a passenger bus. Now, Y, one of the passengers inside the bus, fearing that the gold necklace he bought for his wife would be taken by X, rushed to get out of the bus and jumped through the window. Now, just as X was able to get out of the bus, he was run over by a truck coming from the opposite direction. Y died as a result. Question: what is the criminal liability of X, if any? X will be liable for the death of Y even though he did not touch Y. Because when a person causes a belief in the mind of another, making the latter act in a manner fatal to him, the former will be liable for that act of engendering such a belief. Even if there is no intent to kill on the part of X, he is liable for homicide on the ground of proximate cause. The cause of the cause is the cause of the evil caused. As defined, proximate cause is that which, in natural and continuous sequence, unbroken by any new cause, produces an event, and without which the event would not have occurred. Take note of this. The cause need not be the event closest in time to the injury. A cause is still proximate, although farther in time in relation to the injury, if the happening of it set other events into motion, resulting ultimately in the damage. In the example shown in the previous slide, the proximate cause of the death of Y was not the truck that ran over him, but the act of X in announcing a holdup. When X announced a holdup, it set into motion other events, like fear in the mind of Y. Such fear causing Y to jump out of the vehicle, and the truck hitting and running over Y. The truck cannot be faulted for Y's death because the truck had a right to be in the place where it is supposed to traverse. While the truck may be the immediate cause of Y's death, it is not the proximate cause. To repeat, the proximate cause is the act of X in announcing a hold-up while holding a gun inside the passenger bus. Take note, however, that there should be no efficient intervening cause between the first cause and the resulting injury. Whenever a new cause intervenes, which is not a consequence of the first wrongful cause and which is not under the control of the wrongdoer, then such injurious consequence should not be attributed to the first wrongful cause. For example, X attempted to hack Y, but the latter was able to evade the hacking blow, causing only a small cut on Y's hand. Y then proceeded to report to his work as a janitor, forgetting to wash and treat his wound. 3 days later, Y died of gangrene. Question: is X criminally liable for the death of Y? What do you think is the answer here? The answer is no. The gangrene caused by Y's unsanitary work condition was the efficient intervening cause, so much so that the injury caused by X was not the proximate cause of the death of Y. Small cut lang yung na-incur na injury ni Y galing sa attack from X. A small cut logically and naturally will not result in the death of the other person. So, hindi siya pwedeng maging proximate cause. Ang naging sanhi ng pagkamatay ni Y was not the small cut on his hand, but the gangrene that resulted because of Y's unsanitary work condition. Yun ang efficient intervening cause. And if there is an efficient intervening cause, then the first cause will not be considered as the proximate cause, as shown in the example. Another example, X stabbed Y on the stomach. There was a delay, however, in bringing Y to the hospital due to lack of transportation. 5 hours after the stabbing, Y died of severe bleeding. Charged with homicide, X now claims that the delay in giving medical treatment to the victim was an efficient intervening cause which exempts him from criminal liability. Do you agree with X's contention? The answer is delay in giving medical treatment to the victim does not break the causal connection between the wrongful act of X and the injury sustained by Y. It does not constitute an efficient intervening cause. The proximate cause of the death of Y is the stabbing made by X. Anyone inflicting injuries is responsible for all the consequences of his criminal act, such as death, that supervenes in consequence of the injuries. The fact that there was a delay in giving medical attendance or that the victim did not receive proper medical care would not affect excess criminal liability. The rule here is founded on the policy of closing to the wrongdoer a convenient escape from the just consequences of his wrongful act, because if the rule were otherwise, many criminals could avoid responsibility by merely establishing doubt as to the immediate cause of death. This was the case as ruled by the Supreme Court in People versus Akuram.